So we've talked about Matt Grant. We interviewed Matt Grant. Matt Grant claims to be a very, very successful lawyer, but he filed a completely piece of crap civil RICO lawsuit that Judge Josh Devine, he's in Missouri, took a flamethrower. And they're saying that hopefully if Al Pacino overhears it, he thinks I did a good imitation of him in Scent of a Woman. He took a flamethrower to it, but he gave him a chance to amend it. And this is the amended lawsuit. Look, the first one was 170 pages. This is 185, but a lot of it is exhibits. I think this stops at about 70 pages. He has amended it a little bit. I think Judge Devine is not going to be happy with this amended lawsuit, and he's going to dismiss this lawsuit.
I disagree for this reason. I think that he made a substantial effort to, Matt Grant did, to amend out a lot of the parties that were at issue. He amended out the state of Missouri. He amended out some of the other people. Matt even, I think technically, for a legal standpoint, he can get the injunctive relief some of the injunctive relief. Some of the stuff he said, Mike, we agree was outlandish, like they get rid of the entire judiciary of Missouri and some of the crazy stuff, but that's gone. Now he spent the first few pages here naming the parties, talking about jurisdiction and staking out the claims in a Rule 8 and a Rule 9 specificity that's required under Twombly and Iqbal, which are two very important Supreme Court cases about the pleading standards in federal court. At this procedural juncture, Judge Devine's goal or his exercise here in reviewing this complaint is about plausibility. Does Matt Grant, if we take everything he says is true, assert a plausible claim for relief? And because he recast it in this way, I think that he's over that hurdle. He's not skyscraper jumping over the hurdle, but he's over the hurdle enough, I think, on a lot of these to state a plausible claim. Now, there'll be motions to dismiss, and there'll be all sorts of other stuff, but I think this is going to get at least a discovery on the strength of what we have.
If it gets to discovery, that's effing huge. I don't think it's going to get to discovery because I think he still doesn't have the factual basis to argue RICO. I don't know if
not just arguing RICO, Mike.
Mm-hmm. All right, well then,
RICO stuff. Several things. Go down a little further. He's still talking about the defendant, so his jurisdiction. He talks about all the cases all the basis for jurisdiction. Then he talks about certifying a class. So that's an issue that he has to get through. He could get a class certified. Keep going down. Aside from the class, he has actual facts that are related here, allegations common to all counts. So it's not a shotgun. He talks about the general ones there. Then he goes down and he talks about the specifics within different groups that he identified up above. And then after that, it goes down to the actual claims for relief. So he shows some of the evidence here. Keep going down.
And look, as just one example of the damning evidence plaintiff possesses regarding the longstanding, below is an email that one plaintiff's fact witness will authenticate. And again, we are buying future litigation. That's not from his case. So it shows no evidence of a RICO enterprise in his case. This is a case from 8 years ago. Yeah, I know the case.
Go down to the RICO plea, Michael. Go down to the RICO plea.
RICO, has a well-orchestrated by which it implements its plan to intentionally prolong litigation. That is vague. That is vague.
Mike, go to the claims for relief. Go down further. This is like 80 pages long. Go down to where he starts talking his claims for relief.
I think that I'm not going down that far because I'm sorry. That's
the important part, Mike. That's the important
part. No, it's not because it's way too long. Judge Devine said it was too long. He didn't make it any shorter. This is a garbage lawsuit that's going to be dismissed. He's going to piss off Judge Devine because he didn't really fix it.
I think he already pissed off Judge Devine.
Yeah, well, this is much worse. You've done almost nothing.
You understand about Judge Devine. Judge Devine used to be the Solicitor General of Missouri. Judge Devine was one of the best lawyers around in the country. Okay, strategically, would Judge Devine take it the same way that Matt Grant's taken this case? Probably not. I think Judge Devine probably would have made a 20 to 25 page claim and made it very easy to read, and everybody understand after they're done with it what the story is. That even you can explain it to an 8-year-old after you're done reading it.
You can't explain it. No one can.
He didn't do that, but Judge Devine's goal here, or his exercise
No
here,
one can explain how any of this is a RICO enterprise.
Yes, it does. If you go to the claims for relief, he has enough there to get over the hurdle.
Well, then explain it to me. What does that mean?
To evaluate this complaint, the Second Amendment complaint, and assume that everything there is true, and say, does this meet a plausibility?
Explain it. How is it a RICO enterprise? How is it a RICO enterprise?
If you would go down to the claims, I'll show you.
If you know, I don't need to go to the claims. How is it a RICO?
He asserts that it's done for a fraudulent purpose. He gives examples of the fraudulent purpose. He gives the crimes that are overt acts and predicate acts. So he talks about the use of the mail. He talks about use of the of email. He talks about
the use of a mail to send out
he talks about
that he doesn't like.
A core extortion. Extortion is a crime, 1951.
Right.
There
is
nothing.
nothing.
The bells and whistles are there for the magic words for it to get to discovery, in my opinion. Now, I might be wrong, but in my opinion, the bells are there potentially to get to discovery. That's all.
If he got to discovery, that's a huge victory.